By continuing to be in this meeting, you and other participants are consenting to being recorded. You may choose to turn off your camera. Next slide, sir. Studies have shown between 50 and 60% of African Americans die without a will. Beloved Black legends such as Prince, Aretha Franklin, Chadwick Boseman, and John Singleton did not have a will in place when they passed away, resulting in family conflict. We have seen in our own families conflict that have ensued because the deceased wishes were not known. Everyone thinks they know what Big Mama wanted or Uncle Jojo wanted, but you just don't. You don't agree upon. Does your family know what you want? Is it in writing? Estate planning should not focus solely on what happens when you die, but also include what occurs if you become disabled or incapacitated. What would you want people to do when you can't tell them? You want to be the decision maker. Today, you will be provided with information to help you become the decision maker using legal documents. At this time, we will have readings by Sir Antoinette McIntosh Harper, President of Federal City Alumnae Chapter.
That mute is always tricky. Good afternoon. I'm Antoinette McIntosh Harper, President of the Federal City Alumnae Chapter of Delta Sigma Theta Sorority Incorporated. On behalf of the more than 750 members in the chapter, I welcome you to today's estate planning event. Delta Sigma Theta has advocated for the social and economically disenfranchised, especially in communities of color, for more than 108 years. According to the AARP, more than 50% of Blacks pass away without a will. We are committed to changing that statistic. Estate planning is a key component to creating generational wealth for families and a way to support organizations that serve our communities. Please take good notes and share what you learn with your family and friends. I commend you for taking an interest in estate planning. I hope that the information presented today is helpful in continuing your legacy, establishing your family security, supporting the organizations that serve us, and encouraging our communities to keep circulating that Black dollar. Your attendance is greatly appreciated, and we ask that you continue to follow us on social media and look for our future programming. I especially want to take this time to thank my sorors, Cheryl Steplight, Esquire, Tina Nelson, Esquire, and Michelle Rose, Esquire, for your willingness to share your knowledge and insight today. And thank you to the Economic Development Committee and the Technology Committee for your assistance in planning and executing quality community programming. Thank you and enjoy the event.
So good afternoon. My name is Michelle Rose, and I will serve as the facilitator for our Super Bowl 55 pre-game event on wealth transfer. We are very excited about the information that we have in store for you this afternoon. But first, just want to review a couple of housekeeping items. Please note the disclaimer. The information provided during this webinar does not and is not intended to constitute legal advice. All information, content, and materials are for general informational purposes only and does not create nor imply an attorney-client relationship. Attendees are strongly encouraged to follow up with a legal professional for advice in their respective jurisdiction. So just to review our outline for today, we're going to look at the estate planning basics, and then we're going to take some questions and answers from our audience. Please be mindful of our previous disclaimer. We ask that your questions are not factual specific to your circumstances because we cannot provide that information. Then we'll have a scenario where we want to hear from you and see what your thoughts are before we hear from our experts. Then we'll hear from our representative from legal counsel from the elderly. We'll have another scenario, question and answer section, acknowledgements. There will be an opportunity for resources we received from us, a survey, and then we're going to close it out. Next slide, please. Okay. So our first presenter is going to be Ms. Cheryl Steplight. Ms. Cheryl Steplight is an associate in the Advertising and Media Group in Crowell and Mooring's Washington, D.C. office. Her practice focuses on trademark and brand protection issues involving gift cards and loyalty cards, rewards programs, unclaimed property laws, and trademark prosecution. Having previously served as a trademark attorney for nearly 10 years with the United States Patent and Trademark Office, Cheryl has extensive experience in all manners of trademark and trade dress issues. In her role at the Patent and Trademark Office, she reviewed thousands of trademark cases from the initial application to final registration. In private practice, Cheryl's work experience includes advising all manners of entities from Fortune 500 corporations to small businesses on trademark and brand protection matters. Cheryl is also active in a number of public service and pro bono matters. As a member of the inaugural board of the District of Columbia's Home Educators Association, Cheryl worked with the DC office of the State Superintendent of Education to establish and shape the current homeschooling regulation. Cheryl received a Juris Doctorate from Georgetown University Law Center and earned a Bachelor's of Science in Economics from Hampton University. So before we hear from Sora Cheryl, let's get our first poll question, please. Okay, so we want to hear from you. What do you feel that your estate plan should consider and/or cover? Death, divorce, bankruptcy, disability, all of the above, or none of the above? Okay, we're going to wrap up the polling. So we see that majority of you state that it should be all of the above, which I believe is correct also. But let's hear from Cheryl and see if we're right. Welcome, Cheryl, and thank you for being here this afternoon.
Thank you so much, Sora Michelle, for that wonderful introduction. And this is a really good poll question to get everyone thinking about what should be involved in their estate plan. When I had my own practice, solo practice, estate planning was my passion. And doing events such as this was very important to me because many times people, as you've already indicated, don't have the documents and things in place that are necessary. One thing I would like to share with people, and I always share, is this. When you think about estate planning and when you think about drafting your will, try really hard not to look at it as a morbid, sad kind of thing. It really is an empowering thing. When you put your affairs in order now, think about how hard you work for everything that you have and how much you do to maintain and take care of those things. What estate planning does is it gives you that same control and power over those things that you work so hard for while you're still living and while you're in a position to make those decisions. So sort of look at it that way. Those things are going to outlive you. Where do you want them to go and how do you want them to outlive you and exist once you're gone? So with that, what is an estate? So I included this picture of this palatial property with a long reflecting pond in front of it. When we think about the word estate, it tends to conjure up mansions and villas and property in the south of France. but that's not really what an estate is. So I've included this question: what is an estate, and do you have one? You most certainly do have an estate. Your estate is everything that you own, everything that you own. And there are two basic types of property: real property and personal property. Again, we're going to speak in simplistic terms, recognizing that there's also intangible property, but that's not what we're going to talk about today. So what is real property? Real property is like real estate. So it's your house, and it's the land that it sits on. It's any undeveloped land that you might have. Maybe someone left you some property in the country, you know, the piece of land next to Big Mama and them down in North Carolina. That's your real property. It's also any interest that you have in property. So for example, if you have a timeshare, or if you have a condominium, if you have rental property, all of those things are considered real property. Well, what's personal property? Personal property is everything else. It's your car. It's the ring that used to belong to Big Mama that she passed on to you. It's your favorite sneakers. It's everything else that you own. Your real property and your personal property are what constitutes your estate. Next slide, please. I think I might have, can you all still hear me?
Yes, you sound great.
I think that I'm going to have to pause for a second. I'm
Okay.
going off of the video. But can you take my video off?
Yes, ma'am.
Thank you. I'm sorry.
So then to pick up where Sir Cheryl was starting off, for an estate plan, we have three basic documents. We have a will, a healthcare power of attorney, and our durable, what's also known as a financial power of attorney. Next slide, please. So let's look at that basic will. What is it and why do I need one? So a will is a document that disposes of your real and personal property according to your wishes. Next slide. It allows you to select who gets what and who doesn't get what they shouldn't have. To make provisions for minor children, for example, guardianship, to decide who will carry out your wishes, for example, who will be the executor. And at times, if you have multiple children in your life, maybe it's a particular one is the one that is a little bit more responsible than you want to turn to. If you have siblings, best friends, loved ones, who will that person be? And also to be able to make funeral arrangements. Oftentimes we don't think about it, but the thing I love to cite is The Imitation of Life, and how at the end of the movie, there was already carried out that she would be buried and carried off with the white horses because she planned that in advance. So do you want to be cremated? Do you want to be buried? Do you want to have a service? Do you have a plot of land? All of that are factors that you can take into consideration and state in your will. Next slide. So now let's look at that healthcare power of attorney. Especially with COVID and everyone being very mindful of health concerns and conditions, healthcare power of attorney is probably even more important now than it's ever been. So what is it and why do I need one? It's a document that authorizes another person to carry out your healthcare wishes. Next slide.
Can you all see and hear me? Can you hear me?
Yes, ma'am. We're ready.
Okay. Okay. A healthcare power of attorney. When you think about a healthcare power of attorney, I want you to think about a megaphone, okay? Next slide, please. A healthcare power of attorney is a document that authorizes another person to carry out your wishes for you. So what is that megaphone image? What is that concept? You might tell someone all of your healthcare wishes, but without a healthcare power of attorney, your wishes and their voice can't be heard. And so the healthcare power of attorney is that megaphone that allows them to speak your wishes on your behalf. It is also known as an advance directive or a medical power of attorney or an advanced healthcare directive. All of these things are another name for a healthcare power of attorney. It doesn't matter if that person is a relative. You know, a lot of times people think, well, I'm a relative, so they'll tell me. That's not necessarily the case. I will speak from personal, perspective. I'm speaking legally and personally from providing legal information and personally. I used to give these seminars and speak to people and tell them why it was important for them to do the things that we're sharing right now. But I didn't really understand the impact until I had to experience it. So here I am, big bad attorney, going to the doctor with my family, my father, and I want to know what's going on. And they're like, okay, it's nice to meet you. Do you have power of attorney? And so I share that because I now understand that it doesn't matter if you're the wife, if you're the daughter, if you're the son, especially now with global healthcare being really watched and magnified, and with medical institutions making sure that they're dotting every I and crossing every T, they're going to make sure that they see to it that this document is a part of any patient's file. And so it's not just a matter of, well, I'm the only child, so of course they would let me speak for my mother. Not necessarily the case. So it's important that you have this document. When you have this document in place, it allows you to give consent for treatment, and it allows them to communicate with you and to share with you what's going on in terms of the care of your loved ones and in terms of your care. So if there's something that you want others to be able to do for you, someone to be able to do for you, it's so important that you have a healthcare power of attorney. And I just want to say what it's not. A healthcare power of attorney is not a living will. And a living will is not one of the three documents, but I just wanted, for a point of clarification, a living will authorizes someone to speak on your behalf as it pertains to end of life treatment, whether or not you want your life prolonged in an end of life circumstance. That's what a living will does. A healthcare power of attorney goes far, far beyond that and actually precedes that. It has to do with your care and how you are cared for and treated. When you're thinking about who you want to give your power of attorney to, just like when you're thinking about who you want to make the decisions for you through your will to serve as your executor, I always caution people, don't necessarily pick a child because that child is your oldest, because that child might not be the one that makes decisions in a way that more aligns with the way you make decisions, or that child might not be in a position to carry out such a responsibility. And so I always caution people to think very carefully about who's going to serve in these key roles. Next slide, please. A durable power of attorney. What is a durable power of attorney and why do I need one? This is an incredibly important document. I can't emphasize it enough. A durable power of attorney grants another person the authority to make legal and financial decisions on your behalf. And the reason why it's such a key document, next slide, please, is that not only is this person authorized to make legal and financial decisions for you, but this person is authorized to act on your behalf. What does that mean? What does that look like? They can access your accounts. They can open and respond to mail. They can manage your property for you, and they can act on your behalf with third parties. Reason why another reason why it's a really important document is because it doesn't necessarily come into play or take effect when you are incapacitated. So let's say, for example, you have the durable power of attorney for your mom or your dad or both, and they need some banking done, but they don't feel like going to the bank. If you have durable power of attorney, you can go to the bank and act on their behalf, and you can do so legally. That's the power behind a durable power of attorney. Again, you should think very carefully about who you grant this authority to and who you grant these powers to, because in a durable power of attorney, this person will have this like across the board, and you can determine how much or how little, but this across the board access to act on your behalf. Next slide, please. It's important that you have a durable power of attorney, because without this document, your loved ones will have to go to court in order to have you declared incompetent in order to take care of your affairs. If you think back on the scenario I just presented a few minutes ago, if you're going to the bank to tend to some banking business for your parents, for example, that you have durable power of attorney over, that doesn't mean they're incapacitated. It just means that on this given day, they wanted you to handle this particular financial transaction. But without the durable power of attorney, for you to be able to handle, let's say, that same financial transaction, they have to be declared incompetent in order to take care of your affairs. So it's so much easier to get these things done, to be able to discuss them openly when you can, while you can, and when it's not needed. That way it's not a reactive sort of thing, and it's not something that you're trying to backtrack to get done. Next slide, please. So I want you to remember just these final takeaways, and it's sort of these bullets represent the homework, so to speak, some things that I would encourage you to do when you, after the game tonight, you enjoy the game, but I was going to say when you jump off of this webinar. It's important that you compile a list of your property, your real and your personal property. It doesn't have anything to do with monetary value, especially as it pertains to your personal property. What you really want to think about is what value does it have to you? Compile a list of those things, and then decide who you want to serve in certain roles. The executor of your estate is the person who's going to carry out the wishes of your will. So it has to be someone, I would suggest, that you know is no nonsense. I would suggest that it be someone who's not going to be pressured and pushed around. I would suggest that it be someone who's responsible and diligent in detail. But decide who you want to serve as the executor of your estate. Decide who you'd like to serve as guardian over your minor children. And that's an important thing. Who is the person that can most likely mirror the care that you have and the love that you have for your children, and who would carry out your wishes and who would tend to them in a manner that would be reflective of what you would want. That's the guardian of your children. Think about who you would want to be the guardian. Decide who you would want to make the healthcare decisions for you. Some of the things that I mentioned previously: consenting to certain treatments, receiving all of the information and correspondence from doctors, determining when you're moved and how you're moved. Who do you think would be a good person to make that decision? Decide who should act financially and legally should you be unable to do so. Who is the person that's responsible enough, that's good with money, that knows how to ask the right questions? And then consult with an attorney and get started. If you remember to do these things, you will be way ahead of the game in terms of establishing an estate plan that will be reflective of the work that you've done to earn what you have and all that you've done to take care of what you have. Thank you. And I hope that this is sparking some thought and is giving you a nudge to get started.
So you have definitely sparked thought, because we have a number of questions for you in our chat.
Okay.
So our first question is from Ms. Woods. Can the healthcare power of attorney also make those life-ending decisions if there is no living will?
Yes, as long as you just write it out. And that's the thing. That's what's important, is that you write it down and that you sign it. But yes, you can include that information.
And our next question comes from Ms. Boykin. Do you need a durable power of attorney if you are married? Doesn't your spouse have all of these rights?
Ms. Boykin, I'm glad that you asked that question. It sort of goes back to the scenario that I shared. It is imperative that you both have your own durable power of attorneys, giving that power to the other spouse. It just makes life so much easier, because there are a lot of scenarios, unfortunately, where everything is good when it's good. But when something happens and one person is sick, and then that other person may not necessarily be acting according to that person's wishes. And so I shared that to say that the marital relationship does not always in and of itself mean that this is who I want to take care of these things. So no, don't make that assumption.
And so piggybacking off of that question from Ms. Lekpa, does the spouse of the individual with the durable power of attorney need to be on it even if they are not listed as joint owners on the accounts?
That's a great question. That's exactly why they do need to be on it, because they are not joint owners of the account. So if they're not joint owners of the account, then should something happen, the account is held. It's just held. And they won't be able to come in and do anything with those funds. I know of a of a scenario that's very similar to that, where there were several accounts that the husband held only in his name at different banking institutions, not for any reason, and not for any ill will, but just because. And he unexpectedly passed away. And now his wife, in the midst of her grief, is going through a lot because she has no access to those accounts.
So then, if your name is on the account, do you still need the durable power of attorney?
Not for that account, but for other business, other financial or legal transactions, you would.
And if you wanted to get a durable power of attorney for a parent, what do you do? How do you go about doing that?
You consult an attorney, and they will definitely help you. If your parent right now does not have the mental capacity to grant that power of attorney, then it's too late. And I've seen situations like that as well. That's why I implore everyone who's speaking to me, and those who couldn't be on the call, but you can give them a call afterwards, take care of your affairs now while you can.
And so if you have the will and the durable power of attorney for health care, do you really need the power of attorney for the financial accounts?
They're two totally different things. So your durable power of attorney for healthcare will let you speak to the doctor, but it's not going to let you go to the bank for the other person, or it's not going to let you review any legal documents for that person, or it's not going to allow you to do anything other than interact as it pertains to medical things. So yeah, they're two different things.
Okay, one thing I just want to repeat for all of our audience, and we're so excited to have you here. I am going to try to get through as many questions as possible. We do have a limited amount of time, and we do have another dynamic speaker also. But in terms of the questions, we are not able to answer any specific questions to your situation because we are not providing legal advice this afternoon. We're just trying to give you a general overview and information about the documents that you need to have. But we are going to provide a resource guide at the end of this that will give you the information so that you'll be able to find referrals for an attorney and get assistance in terms of that. So I just want to say that I do see some of those questions, so just please note that we're not able to address that. And I'm going to take one more. What about a pay on death?
I think we're going to discuss that in the next.
I think so too.
Yeah.
Given that, let's move on to our scenario. And we're going to hear from our audience, and then Sora, Cheryl, don't go anywhere because we're going to come back to you to find out what the actual answer is.
Okay.
Okay. So our first scenario. Robert and Linda are married but have been estranged for the past 15 years after Linda had an affair. Linda lives with the man she cheated with. While watching Super Bowl 55, Linda gets so excited over her favorite Kansas City quarterback scoring the game-winning goal that she has a heart attack. At the hospital, the doctors need permission to perform a specific type of surgery, but Linda is unconscious. Linda never designated who would make healthcare decisions for her by creating a healthcare power of attorney. So what will happen next? So Erica, are there any hands raised? Can we hear maybe some thoughts from two of our audience members?
Yes, thank you, Sora Michelle. We have two hands raised. We have Shirley Lakpa and we have Sheila Bunn.
Okay, let's take Miss Lapka. I heard your name mentioned first. Hi and welcome, and please tell us your thoughts.
Hi, everyone. So because Robert and Linda are still legally married, I believe he would have power over attorney for her or next of kin. I don't believe the man that she cheated with would, because he has no legal attachments to her. He could just be a roommate, and I don't believe roommates can have power over attorney. So I think it would go to her next of kin or Robert, her husband, if they're still legally married.
Okay, great answer. And let's hear from Miss Bunn.
I think I would have to agree that because Robert and Linda are still legally married, the doctors would look to him as her next of kin and legal spouse at the time of her incapacitation.
Hey, Sora, Cheryl, what's the real answer? Is Linda gonna be in trouble because she had an affair and her husband still gets to make decisions?
Well, Linda not in trouble because she was with the person that she wanted to be with, but her husband is the one that, generally speaking, they're going to come to next. If they did not legally get a divorce or legally separate, or she did not legally put in any healthcare planning, they're going to go to her husband.
Okay. All right. So that for all of our attendees, you were correct. And so that is the correct answer. And let's go on and move forward. And let's see what our next poll question is. Thank you so much, Sora, Cheryl, for your information. And we will be coming back to you towards the end because we have a lot more questions in the chat.
Okay.
So our second question this afternoon is, I have ownership interests in which of the following? A family business, real estate? Are you inheriting anything? All of the above or none of the above? If you could please vote now. And I'm going to close off the voting after 45 seconds. Okay, so based on the responses we received, see a good amount of you have you own property of real estate in some way, that a lot of you actually have all of the above, which is just wonderful. You see the family business, the inheritance, but for those who don't have interest in anything, don't worry, there's nothing wrong. That's what we're here for, is to talk about building generational wealth and how to also successfully pass it along. So let's move on now and be introduced to our next speaker, Ms. Tina Smith Nelson. Next slide, please. So Ms. Nelson is a manager and supervising attorney with AARP's Legal Counsel for the Elderly, where she manages civil litigation on behalf of seniors in the District of Columbia within the economic and healthcare security practice. That encompasses 5 projects: public benefits, the Veterans Advocacy Project, the Homebound Elderly Legal Project, probate and estate planning, and the self-help offices. Ms. Nelson served in past leadership roles with the DC Consortium of Legal Service Providers. Prior to joining the Legal Counsel for the Elderly, Ms. Nelson worked as an investigative counsel with the Office of the Inspector General, Legal Services Corporation, and as a supervising attorney with the Maryland Legal Aid Bureau. As an adjunct professor, Ms. Nelson taught classes and seminars at the Howard University School of Law, the University of Maryland School of Law Summer General Law Clinical Program, and Montgomery College. She's a past board member of the former DC Law Students in Court program, now Rising for Justice, and has served on the Montgomery County Commission on Landlord-Tenant Affairs. Ms. Nelson earned dual Bachelor's of Arts degrees in Political Science and Sociology from the University of Pennsylvania, and a Juris Doctorate degree from the Marshall Wythe School of Law at the College of William and Mary. Thank you for being here this afternoon, Ms. Nelson. So let's go to our next slide. And just that friendly reminder again that the information provided during this webinar does not and is not intended to constitute legal advice. All information, content, and materials are for general informational purposes only and does not create nor imply an attorney-client relationship, and that attendees are strongly encouraged to follow up with a legal professional for advice in their respective jurisdiction. Next slide. So welcome, Tina, and we look forward to hearing from you.
Thank you very much, Michelle. Good afternoon first to my sorors of the Federal City Alumnae Chapter. And thank you and welcome to everyone who is a part of this webinar this afternoon. It's my pleasure to share with you a little information about Legal Counsel for the Elderly, the services that we provide to seniors in the District of Columbia, as well as to pick up a little bit of where Cheryl left off with regard to estate planning. So hopefully the information that you will receive today, you can share with others who are not able to participate in the webinar, and they can get these services provided for them as well. As it was stated, I am a manager with Legal Counsel for the Elderly. I have been there for 10 years, and we provide a myriad of legal assistance and some social work assistance for, again, low-income seniors in the District of Columbia. So next screen, next slide. Thank you. At LCE, we have a succinct mission, and that is to champion the rights and dignity of seniors who are living in the District of Columbia, to provide vital legal services and social work services to them at no cost. And so what we do with seniors in terms of representing them and advocating for them is also to empower them to advocate for themselves, to defend themselves and protect themselves from predatory lenders and other people who seek to do harm to them. So our mission, is one of support and service to the senior community in the District of Columbia. Next slide. So in order to get services from legal counsel for the elderly, you have to be at least 60 years older, and you have to live in the District of Columbia. We are an affiliate of AARP, but you do not have to be an AARP member for our services. And as I said, we are a legal services organization. And so you have to be low income to receive our free services, but we do have other services that are available for individuals who are moderate income as well. But in order to receive our free services, you have to, again, be low income. That means you have to be at about 200% of the federal poverty guidelines. But we do have services that are available not only to low income seniors in DC, but to moderate income citizens of DC, as well as anyone who is a senior in the District of Columbia. You can get advice, counsel, and referral information by calling legal counsel for the elderly. Next slide. Go back one slide. Yes, thank you. So what types of services do we provide at Legal Counsel for the Elderly? We have two sides of our organization. We have a legal services side, which I'm going to talk about a little bit first. And then we have a long-term care side, because we are the district's long-term care ombudsman program as well. So in terms of legal services, we have a legal hotline, and that hotline is staffed by attorneys who can provide advice, counsel, referral, brief services to any senior in the District of Columbia, regardless of your income. You can call our hotline and get that advice, counsel, and referral information. We also have a tenant advocacy and support practice. And within our tenant advocacy and support practice, we assist seniors with landlord-tenant issues. So if there's a breach of lease issue, a non-payment of rent issue, a conditions issue, we have attorneys in our tenant and advocacy support practice who are able to assist those seniors with those court cases. As a part of our tenant and advocacy support practice, we also have full-time and part-time social workers. So we have seniors who may be at risk of eviction for hoarding issues. And so with the social workers' help, they can get the support they need in terms of counseling, and they can also get assistance from volunteers, both inside and outside of AARP, who actually go to those seniors' homes and help declutter their homes so that they don't risk eviction. So they don't risk eviction. So that's what we do with our tenant and advocacy support as well. We also have our consumer fraud and financial abuse practice. And that particular practice deals a lot with foreclosures. So if we have seniors who are at risk of foreclosure for failing to pay their property taxes, or who may fall behind on a mortgage or reverse mortgage and the lender forecloses. If you are getting work done at your home by a contractor who doesn't complete the work or does work that is not sufficient, those types of things you can handle through our consumer fraud and financial abuse practice as well. And so we represent seniors in those types of legal matters. Our next practice is our economic and healthcare security practice. That is the practice that I manage at LCE. And within our practice, again, we have several projects. We have our Homebound Elderly Project, which assists seniors who are physically unable to come into our offices because of their disability. We actually go to their homes, at least pre-COVID we did, and assist them with any legal matter they might have. We also have, as a part of my practice, our public benefits project. So we assist seniors both at applying for benefits as well as representing them on appeal. So if you're applying for Social Security, Medicaid, Medicare, SSI, which is Supplemental Security Income, SSDI, which is Social Security Disability Income, we can assist with actually applying for those types of benefits. And if a senior gets notice that their benefits are either being terminated or they're being reduced, then we can assist those seniors in appealing those benefits either with the DC Office of Administrative Hearings or with the Office of Hearings and Appeals for Social Security matters. As a part of the EHS practice, we also have a veterans advocacy practice where we represent veterans and spouses of veterans in applying for various veterans benefits. So that would include VA pension, it would include death benefits claims, some service-connected claims, also representing spouses and applying for benefits once their service-connected husband or wife passes. We can assist veterans and spouses of veterans in applying for the various benefits that may be entitled to receive as well. We also have our probate and estate planning project in which we assist seniors in opening probate estates in the District of Columbia, primarily for the purpose of transferring title. Sometimes seniors want to sell the property and distribute the proceeds to the heirs, but our practice is primarily focused on those seniors who want to transfer title. Oftentimes we're representing seniors who are in homes that are deeded and titled in their parents' names, sometimes their grandparents' names, and the last deeded owner died in like the 1970s. So we're assisting those seniors in probating those estates so that they can be on title to the property and they can take advantage of several programs that the district offers in terms of home ownership. So they can get the homestead exemption. They may get the senior homestead exemption, which will greatly reduce their property taxes. They can also be eligible for loans to make repairs to the property. And if a spouse dies, then they can work with the bank and with the Office of Tax and Revenue to take over the loan for the spouse who died so that they can continue to maintain that residence. And then we assist those seniors through the probate process in preparing the documents that Cheryl spoke about earlier, the wills, the powers of attorney, the transfer and death deeds, so that they can maintain that home ownership and then they can transfer that generational wealth down to their heirs. Also within our economic and healthcare security practice, we have our self-help offices. And I think I'm going to talk about that. There's a little slide later about the self-help offices and what we do through that particular project. And our other project we have at practice that we have at LCE is our pro bono access to justice practice. We have about probably about 65 staff at Legal Counsel for the Elderly. And every year we get over 5,000, 6,000 calls from seniors in the district who need legal assistance. And obviously, because we have a small staff, we are unfortunately unable to represent everyone who calls our office. But we are able to represent more people because of the great collaborative practice that we have with private attorneys in the District of Columbia. And so through our pro bono access to justice practice, we are often able to place cases with the private firms in the District of Columbia. And because the senior would be eligible for free or reduced legal services with LCE, these private attorneys do not charge our seniors as well. And so we place individual cases with the private bar. We also place systemic cases with the private bar as well. We work cases with them. So it's good that we have a great relationship with the private bar in DC because it enables us to be able to reach more seniors and provide more services than we otherwise would be able to do. And our systemic advocacy practice is also a part of our pro bono practice. Through that particular practice, we place a lot of systemic issues. So sometimes a senior may come in with a particular issue for themselves, but it would have a great impact on the whole senior community within the district. And so that becomes a systemic advocacy issue. And we are able to place that particular case oftentimes with a private firm who has the financial resources and also the manpower to be able to take those long cases, those systemic cases that we're unable to take in-house because of our limited resources within LCE. So those are the in-house legal services that we provide. Next slide. One of the services that we provide that is really unique to legal counsel for the elderly that I alluded to earlier that falls under my practice, the economic and healthcare security practice, is Project Help, which is our homebound elderly project. And so again, for that particular project, which is unique to legal counsel for the elderly, I don't believe any other legal services organizations in DC have homebound projects where they actually make house calls. And so again, pre-COVID, we were actually going out to seniors' homes. We were going out to nursing homes, other long-term care facilities, and assisting those seniors with whatever legal issues that they were having. We have had to pivot because of COVID, so we are still able to provide some services to the homebound community, even in a virtual environment. But most of our work through our Project Help is actually done in the community at the homes of those seniors. Next slide. Another of our outreach services that we have at LCE is called Active Intake. And again, pre-COVID, we would conduct clinics at various senior centers throughout the District of Columbia. And we would actually meet with the seniors in the community. We would conduct an intake with them to find out what their legal issue is. And oftentimes seniors don't know that they're having a legal issue. So we basically just find out information about what's going on in their lives. And then we determine and can assess whether or not whatever issues they're having in their personal life really is a legal issue that legal counsel for the elderly can assist them with. And so when we have that pre-COVID, and hopefully after COVID is over or contained, we'll be able to get back in the community with these services as well. But we have active intake at those particular sites, the Emory Senior Center, Martha's Table, the Reeve Center, Sarah's Circle, and the Lisner Louise Dickerson Hunt Home. And so we actually meet with community seniors outside of our office, again, to conduct an intake, to find out what services they might need, and pair them either with a pro bono attorney, or if it's something that we can handle in-house, we will handle that matter for the senior as well. Next slide. And the other thing that we have at Legal Counsel for the Elderly that falls under my practice area is called SHELL. It's our self-help offices. And we kind of think about this as community lawyering. So we have 6 sites throughout the District of Columbia. Again, pre-COVID, we had a legal associate who was staffing these sites 1 day a week and providing services for the seniors in the community. And these services are typically services that don't require extensive litigation and extensive representation. So completion of an application for Social Security, assistance in writing a demand letter or complaint letter, assistance with getting your credit reports and reviewing your credit reports, and maybe writing a letter to the credit reporting agencies to dispute something on your credit report or to ask for an investigation of your credit report. Those types of brief services we offer through our self-help office. And we have 6 sites throughout the District of Columbia: at Iona Senior Services, at Downtown Clusters Geriatric Daycare Center, at Bread for the City, at Israel Manor, Inc., which was Israel Manor Baptist Church, at the Dorothy Height Library, and at AARP, our DC State Office. And so we are right now in 6 of the 8 wards. Again, we have a legal associate who actually meets with the clients in the community to assist them with their brief service matters. And again, we've had to pivot because of COVID, but we are still able to assist seniors in a virtual environment with whatever brief services matters they might have as well. Next slide. Go back one more. Thank you. And in addition to legal services, as I said, part of legal counsel for the elderly is our long-term care. We have a contract with the District of Columbia, the Department of Aging and Community Living, to provide long-term care services through the DC Long-Term Care Ombudsman Program. And so our office, through our Ombudsman Program, has oversight over all of the nursing homes, the board and care facilities, the home and community-based services in the District of Columbia. So if there is a complaint that a senior has about the care that they're receiving at a nursing home, then we can investigate that complaint that's either brought by the senior themselves or brought by a family member about the healthcare treatment that a senior is receiving in one of the long-term care facilities. We can investigate them ourselves, but we can also investigate them with the Department of Health if it's an issue that we cannot resolve with our ombudsman program. In addition to nursing homes, many seniors are actually receiving nursing home level of care in their homes through what's called the Elderly and Persons with Physical Disabilities Waiver Program. That's part of the home and community-based services that the District of Columbia provides. So these are seniors who are receiving home services through home healthcare agencies, and they don't have to go to nursing homes. And so, as a part of our ombudsman office, as well as my team, we assist seniors who are having issues with the waiver program. So either their application has been denied, or they are being reduced or terminated from the program after they've been reassessed, and they need legal assistance in representing them at administrative hearings at the Office of Administrative Hearings. So both our ombudsman program handles that, and they actually handle those cases for anyone who receives home and community-based services. So you don't even have to be a senior. Or the legal side of the program, you have to be a senior. But for our ombudsman program, anyone who is receiving long-term care in the District of Columbia can get assistance through our ombudsman's office. And lastly, as a part of our non-legal services, we have our Senior Medicare Patrol. And what they do is, again, pre-COVID, they would go out into the community to senior centers, to libraries, to faith-based communities, to churches, to do presentations and outreach to advise seniors about Medicaid fraud and Medicare fraud, how to protect yourself from fraud. And if a senior suspected that they were a victim of Medicaid or Medicare fraud, they can bring that to the attention of our S&P staff, and they can initiate an investigation as well. So they teach seniors how to go through their Medicaid notices to make sure that whatever services Medicaid is being billed for are services that they receive, because oftentimes Medicare fraud involves doctors and other entities charging the seniors for things that they never got. Durable medical equipment that may have been ordered, a wheelchair that was never received. And again, so the S&P staff, they go out, they help seniors to understand what fraud is, how to protect themselves from fraud, and also if they are a victim of fraud, to assist those seniors in filing complaints so that it can be investigated. Next slide. Okay, so I'm going to switch hats. So those are all the services that we provide at Legal Counsel for the Elderly. As we go through these slides, you will see on our last slide our hotline number, and you are certainly happy to and encouraged to call our hotline number if you need legal assistance. Again, as I said earlier, our cutoff is really for low-income seniors who are about 200% of the poverty guideline, but I would not let that prohibit you from calling Legal Counsel for the Elderly, because as I said, through our hotline, you can get information, advice, and referral from all of our hotline attorneys, regardless of your income. And also, as a part of Legal Counsel for the Elderly, if you are a little over income, for our free legal services, we do have a relationship with the private bar through our what's called our reduced fee panel. And so you may be able to get an attorney through our RFP who, let's say, if you're not eligible for a free legal attorney to provide, services to get a will, a power of attorney, a transfer and death deed, you can get an attorney through our reduced fee panel who will be able to prepare those documents for you, but at a greatly reduced cost. So the fact that you may be not low income should not preclude you from calling our office, because you can get information and referral from our hotline. You may be able to get an attorney through our reduced fee panel. And if you do live outside of the District of Columbia, because I said We are limited to providing legal services for DC residents. If you live in Virginia or you live in Maryland, you can certainly give us a call and we will direct you to a legal services organization in your jurisdiction that you can contact to get these documents prepared as well. So I'm happy to answer any questions at the end about legal counsel for the elderly in our services, but I want to switch gears a little bit and kind of piggyback on the estate planning information that Cheryl provided earlier. So if you could go back one more slide. Right. Okay, so oftentimes we have seniors who come to us and they're really the only asset or the major asset that they have in their estate is their home. Um, and as Cheryl says, your estate encompasses everything, your real property, which is the houses and land, and the personal property, which is everything else. But if you are in DC, and I believe in Virginia as well, and Maryland is on its way, there is an instrument called a transfer and death deed. And that allows you to transfer title to your property to a beneficiary without having to go through the probate process at your death. So the person that you name as the beneficiary to receive your property will get your property at your death without having to go through probate. So that's a great tool that's available to residents of DC and Virginia because the probate process itself can be expensive in terms of opening probate, paying the money for all of the notice requirements, the publication in newspapers. It can be expensive. So this allows you, especially if your home is really the major asset that you have and you know to whom you want to give it to, you can prepare the transfer and death deed. The transfer and death deed must be recorded at the Office of Recorder of Deeds in order to be legally sufficient. So in order to have legal effect, you can prepare the transfer and death deed, but you have to record it with the DC Office of Recorder of Deeds. And if it's not recorded, unfortunately, it does not have any legal effect. And so your home would have to transfer either through the provision that you have stated in your will or through intestate succession if you have not prepared a will. So the TODD must be recorded at the Office of Recorder of Deeds in DC. The TODD is revocable during the life of the transfer. So that means if I decide today that I want to prepare a transfer and death deed and leave my property that I own in the District of Columbia to my husband, and next year I decide I don't want to leave it to my husband, I would rather leave it to my grandchildren, I can always revoke it and create a new transfer and death deed and then record that with the Office of Recorder of Deeds. So it's revocable. As long as I'm alive, I can make whatever changes I want to with my property. The next says the transferor is free and controls the property up until the time of death. This is very important because we often get questions, especially from seniors who call in and they say, well, can I add my children to my deed? And can I add my grandchildren to my deed because I know I want them to get the property when I die? And our answer is legally, yes, but we certainly discourage that because when you have a deed with various people's names on the deed with you, everyone has a legal say in what happens to your property. And you cannot do anything with your property unless everyone who is on the deed with you consents and agrees to the action that you want to take. So that means if you decide you want to get a loan, if you want to get a reverse mortgage, if you want to sell your property, before you can do any of that, everyone whose name is listed on the deed with you has to agree to the action that you plan to take. So with a transfer and death deed, you can do what you want to ultimately do, which is leave that property to your beneficiary without them having to go through probate, but it allows you to have total control of your property up until the time of your death, because the TODD only becomes effective at the death of the transferor. And then there's one other requirement. Once you pass and the person that you have designated as the beneficiary to receive your property, that person will simply file a conforming deed and file that with the Office of Recorder of Deeds, and they don't have to go through the whole probate process of getting letters of administration issued and going through the courts in order to get the property that you've left. Next slide. Thank you, Sora. I think someone put this in the chat. They had some questions about trust. We don't do a lot of trusts with legal counsel for the elderly, but trust is another tool, if you want to think of it, in your kit of estate planning documents that you can get prepared. And basically, a trust document is something that you would create that is funded by money that you have, that you set aside for a particular person for a particular purpose. So a testamentary trust is a trust that you create that is funded by money after you die. So let's say if I know when I pass that I want a particular amount of money set aside for the education of my grandchildren. And so I want to create a trust for them, and I want to put $25,000 or $50,000 in this trust for my grandchildren's education. So I can create this trust provision within my will, and I will designate a trustee if the beneficiary is a minor, who would govern the trust until the person comes of age. So that again is another instrument or another document that you might consider having drafted if you want to set aside, again, a particular amount of money to a particular person for a particular purpose. Again, it's often used for minor children or disabled children, but that is another estate planning tool that you may want to speak with an attorney about getting prepared as well. Next slide, please. The other type of trust is called a living trust. And the living trust, that means that the money passes into your trust during your lifetime. So once it passes into your trust during your lifetime, you no longer have any control over it. Unlike the testamentary trust, as long as you're alive and it's a revocable trust, you can always change it, revoke it, do something else with it. But if it's a living trust, that means that money has passed to that trust while you are alive. And so at your death, it is no longer a part of your estate because it has already passed outside. Oftentimes people use this to avoid probate. So they want to, make sure that whoever they may be leaving money to or property to, may not have to pay as much taxes, inheritance taxes or something like that when they die. And so they want to put this money already in a trust for that person. But it requires that all the assets must be transferred into the trust at the time that it's created. You can't say that I want this money, $25,000, to be set aside after I die. You have to have the money available right now in order to create the living trust. But if you think that you might have the money available at your death, let's say you advise your executor or your person representative to sell your property at your death, and then from that money you want them to create a trust for your grandchildren. That is fine with a testamentary trust because the money is coming later. But in terms of a living trust, the money has to be transferred into the trust at the time that the trust is created. Next slide. Thank you. And there is some property that actually passes to the person who is the beneficiary outside of your will and outside of the probate process. So let's say if you have a life insurance policy and you have named someone as the beneficiary of that policy, by operation of law, that person is entitled to receive that property at your death. And so what I often have my clients do is to make sure that they look back at those life insurance policies that they have. You may have gotten that policy 20, 30, sometimes 40, and in my clients, since they're seniors, sometimes 50 years ago. So you want to make sure that the person that you designated as the beneficiary of that policy at the time you got that policy is still the person that you want to receive that money. The beneficiary may be someone you divorced may have been someone that died. And so, again, by law, those individuals are entitled to their property at your death. So you need to make sure that the beneficiary information is up to date, and the individuals that you intend to get that property at your death are the ones that are included on those life insurance forms as the beneficiaries. It's a very simple process. If you need to update that, you simply need to contact the insurance office. They will send you and let them know that you need a new beneficiary form. They can send you the form, you sign it, you get it notarized, and you send it back to them. But you want to make sure, again, to look at those old policies that you have to make sure that the beneficiaries are still the people that you want and intend to get that property at your death. You also may have a payable on death bank account. That money by law passes to the surviving joint tenant at your death, and they don't have to go through probate in order to get that money. It passes outside of your will and outside of the probate process. And then lastly, if you have a retirement account, and again, if you have someone who's named as the beneficiary, by operation of law, by law, they are entitled to receive that property at your death without having to go through the probate process. Any jointly held property that you might have, by law, passes to the surviving joint owners at your death, and they don't have to go through the probate process in order to receive that property. So there are some situations in which you can have property that passes to your loved ones or whomever you have designated as your beneficiary without them having to go through the probate process. Next slide. So this is our hotline number. For those of you, I don't know if anyone is on the phone, but the number is 202-434-2120. Again, 202-434-2120. And our hotline is open Monday through Friday from 9 to 3. And you should call legal counsel for the elderly if you are a senior in the District of Columbia, or you know of a senior who lives in DC. Give them our number if they are in need of not just these estate planning documents, but if they're in need of any services that I spoke about earlier, whether it's a housing issue, whether it's a consumer issue, whether it's a public benefits issue. Give them our number, have them give us a call, and we will be happy to assist them where we can. Thank you.
So thank you so much. There are tons of questions for you in both your capacity with legal counsel for the elderly, but also regarding the transfer on death deeds. So I'm going to start with the latter. Can you do a transfer on death deed while there is still a mortgage on the property, or is it only available after the house has been paid off?
Very good question. You can do a transfer on death deed if there's a mortgage on the property, with the understanding that you can only transfer the ownership interest that you have. So that means they can get that property, but it comes encumbered with whatever lien or mortgage that you have on the property. But yes, you still can.
And given that we're in the pandemic, if the recorder of deeds is closed, how do you get the form recorded?
Good question. You can still record TODDs with a recorder of deeds by going to a website called deeds.com. And you can record your deed with the recorder of deeds office before they open again to the public, because right now they are closed. But if you go to deeds.com, then you should be able to record your TODD with the Office of Recorder of Deeds.
So can you transfer on death deed to a trust, or is it only that it can go to another person?
I believe the way that the law is written in the District of Columbia, it can only go to a person, not to a trust.
And one thing we do want to acknowledge is that definitely feel free to speak to an attorney when considering this, because as pointed out by Ms. Somerville, that there are many title companies that still insist on probate, creditors' claims, etc.
Exactly. Transfer and death deeds have only been allowable in the District of Columbia since 2013. And I do know that there are some title companies that don't recognize transfer and death deeds, and they are insistent upon the person who is receiving the property to go through the probate process to get letters of administration to receive the property. It has not yet been litigated in DC, but I anticipate that at some point, someone is going to bring a lawsuit to get this issue settled. But yeah, some of the title companies are kind of pushing back on TODDs.
And can you do a transfer on death deed for more than one property?
Yes, as long as you're an owner in that property, you can prepare a transfer on death deed designating the beneficiary or beneficiaries whom you want to get the property. But if you are naming more than one person, you need to be clear on your transfer on death deed how those individuals will own the property. Will they own it as joint tenants with rights of survivorship, or will they own it as tenants in common? So if you think about it as a joint tenant, once one joint tenant dies, the surviving joint tenant gets the property. But if it's a tenant in common, that means think about it as a pie, that it's forever cut into slices of the pie. And that slice of pie is forever mine. And my heirs get my slice of pie once I die.
Now we're all going to look at pie a little bit differently from that point. I like that analogy. So I'm going to switch over to trusts. Are trusts revocable?
Yes, you can have you can have both a revocable trust and an irrevocable trust. So it depends on your wishes and what you are trying to get accomplished. There are different tax implications as to whether or not it's revocable or irrevocable. And so I would encourage you that if that's something that you're really interested in pursuing, that you speak with an attorney in your jurisdiction who really specializes in trusts.
And we're going to now swap back over to your role with AARP, Legal Counsel for the Elderly. So you stated about 200% of the federal poverty guidelines.
Mm-hmm.
Is exactly what's that amount?
I don't know the figure in my head, and you don't have to figure it out either. When you call our intake line, you will be connected with an intake worker, and they will get demographic information from you, your name, your address, your income, how many people live in your household. And from that, we determine whether or not you are within our guidelines to receive free legal services. There are some things that are discounted, so we discount the first home that you own. There are also some asset limits, but you don't have to try to figure that out. When you call our intake line, we will go through the calculation to determine whether or not you're eligible for our free legal services.
So how are seniors made aware of your services? And right now you have people ready to take up the charge. So how can we advocate to get you more money?
Okay. Well, in terms of getting to know LCE and the services we provide, part of our office is big on outreach. And so we have outreaches that we do with churches. We have outreaches that we do with all the senior centers in DC. We have community partners with like Iona, Department of Aging and Community Living. Um, we we target certain other groups as well. Like we do targeted outreach to the Latino community and the Asian community, the LGBTQ community as well. We have um, opportunities to do media. We have every Monday, not every Monday, like the first Monday of every month, we are on the Senior Zone, which is a radio show in the District of Columbia, where we are a part of that radio program, and we respond to answers to callers, and we provide presentations on various topics that are of interest to seniors in the District of Columbia. So you can find us on the radio. We are all over the place, but if you're in an organization that you would like us to come and talk about legal counsel for the elderly and the services that we provide, please let me know. We have an outreach committee within my office, and we're always looking for places to reach seniors. And so if there's a place out there that we haven't gotten our fingers into yet, please let me know, because we certainly want to speak with you so that we can schedule that opportunity. And in terms of funding, fortunately, we are affiliated with AARP. So some of our funding comes from AARP, but we also have grants from other government agencies within the District of Columbia. So we receive funding from the Department of Aging and Community Living. We receive funding from the Mayor's Office of Latino Affairs. We receive funding from the DC Bar Foundation. They fund us. So we also have private funders and government funders as well. But if you ever have to testify before the DC Council and you want to put in a plug for legal counsel for the elderly, that would be great. And so again, the funding that we get, let's say again, from DACL, you know, the more that the council is aware of the good work that we do and the need for legal services, especially for low income seniors, tout our successes and help us get more funding so that we can provide more services. Thank you.
And as a follow-up, are caregivers or seniors able to call your number for services?
I'm not sure what they mean by receive services. So if a caregiver, so I'm not going to guess.
I think it's a caregiver on behalf of the senior, and maybe the senior might not be in the position to reach out directly. Can they try to arrange for services on behalf of that individual?
Yes. So if you're a caregiver and you want to call in because someone that you are caring for needs legal assistance, you can certainly call in as a point of contact. When you call our intake line, I would suggest that you at least have the basic demographic information about that senior, again, name, address, a little bit what their income is, so we can determine whether or not they are eligible for our free legal services. And in terms of being able to actually represent that senior, we do require that they have a level of capacity to understand that they are contracting with legal services for the elderly for a particular service. They don't have to know all the legalese. And if they're not able to do so, then if you are a power of attorney or you are a guardian, then you can assist us in providing representation for that senior. But yes, anyone can call in on behalf of the senior. At some point, we will need to actually talk to the senior because they are our client. But as a point of contact of getting in the door, yes, certainly you can call our hotline number to get a case started.
And so, you know, we've gotten a lot of amazing information. We've stated that there are a lot of documents to be mindful of when you're doing your estate planning, but it's a little overwhelming. So what order do you recommend that they get started in preparing the various documents? Is it designating the life insurance beneficiary, setting up a trust, creating a will, the transfer of death deed, power of attorneys?
It is a lot. And that's why we suggest, as Cheryl did, that you find an attorney, because the attorney will talk with you about what your outcomes are, what of these documents that you need, and which of these documents you need to get done before the other. Oftentimes with my office, we do all three. We do a will, we do a power of attorney, we do a financial power of attorney and a healthcare power of attorney. We do a transfer and death deed. We do it all at one time. But if you're paying for these services, it might be a little expensive to get all of these things done at the same time. So that's why a consultation with an attorney as to what's going on in your life right now, that would also determine like which of these documents I need to get prepared right at this moment. So have a conversation with the lawyer. They'll help you figure out what's going on in your life and which document you should get prepared in the immediacy.
And so are there any opportunities for attorneys who might practice in a different field to serve as a volunteer or pro bono with your organization?
Yes, yes, yes. We are always looking for volunteers, always looking for volunteers. I will provide my contact information. Well, the SORAs have it at Federal City. And if you are interested in volunteering for legal counsel for the elderly, please contact them and they will contact me, and we will make sure that we get in contact with you. We do, again, have attorneys and non-attorneys as volunteers with legal counsel for the elderly. It may be something you can only volunteer a couple hours a week. That's fine. You can help us call and make appointments with seniors. You can help serve as a witness for someone's power of attorney or for their will. You can help us when we're out of COVID, go to the seniors' home and declutter their apartments and their homes so that they don't risk eviction. So there's always an opportunity to volunteer at legal counsel for the elderly, and we can give you as much or as little as your time allows.
So I'm going to also bring back our first presenter, so Cheryl, because I know that I have a couple more questions that are for both of you. But I think she might have wanted to comment. So Cheryl?
Can you hear me?
Yes.
Okay. I just wanted to add, just as a final thought before you go to the other questions, is that, we have overall encouraged you to get this done, to get your affairs in order. In every jurisdiction, in every state in the country, there is something called intestate succession. So when you die without a will, you still have a will. And what that will is, I'm calling it a will, is that every state has determined how your property will pass should you die intestate. And intestate means you died without a will. So the question isn't really, do I have a will? Because there is a process and a mechanism and an order by which your property passes. The question is, am I going to be the one to determine how my property passes? Or am I going to let Maryland or Virginia or Delaware or Pennsylvania or Michigan determine how my property passes? And so I just want to let that be mindful to you as you're thinking through and feeling overwhelmed or feeling like, this is too much for me to do. You really do want to take a look at that. And you can Google the intestate succession laws in any state, and it's going to list the order. And then many times the state and the jurisdiction is going to go first. They're going to get whatever money you owe them, and your creditors are going to go, and everybody is going to get what the state deems they should get before it gets down to the way that you might want your property to pass. And so I just want you to be mindful of that.
And I will piggyback on what Cheryl said, that your property, so your property will go to your heirs. And as she says, each jurisdiction determines who your heirs are and in what priority. And so you may end up having someone receive your property that you never intended to receive it. I always talk about how, y'all know in our community, we may have gotten married, but so-and-so moved out and I haven't seen them 30, 40 years, but we never bothered to get divorced. When I die, that person is an heir if I die without a will, and they can receive, and by law, they will receive part of my estate, even though I never intended them to do. And the court don't care, or jurisdictions don't care, whether or not there are other children that are born inside or outside of the marriage. And so again, to protect your property and to ensure that your assets go to the people that you, yes, we definitely encourage everyone to get a will, or at least get a divorce. If you don't want to get a will, at least get a divorce, so that husband that you haven't seen in years and years and years does not get your property when you die.
And for the men on the call, same for you, get a divorce so the wife that you haven't seen in a decade or more does not all of a sudden get to come back and take things.
Exactly.
So for both of you, what are your thoughts about services such as LegalZoom.com and similar free online templates to create those necessary documents?
So I'm not sure what Soratina's going to say. I'll start with this. Something is better than nothing. So having something in writing is better than just the conversation that you had after Thanksgiving dinner when you went over and sat on the porch with your cousin. But with that said, it's like everything else. You get what you pay for. And if you sit down with an attorney, they can walk through your specific circumstances and your specific situation, and may be able to give you a more personalized and customized process. I think I saw a question in the chat about cost. I mean, that varies just like everything else. And so you have to maneuver that on your own. But at the end of the day, I think that something is better than nothing, but you can get something that's more tailored and customized for your needs.
And I would add that, yes, something is better than nothing. And I think that those forms that you can get on the internet, it's a good place to start
Mhm.
because it will give you an idea of what the process looks like and what the documents look like. But I would caution relying solely on those internet documents because every state and jurisdiction is different. So it does you no good to go through the process of creating a will or power of attorney, and your particular state has certain requirements in order for that document to be legal. So let's say you might have a state that says it has to be notarized, but there's no notary stuff on the one you pulled offline. You might have a jurisdiction that says you need one witness, or you need two witnesses, or you need one witness and you need a notary. So there are specific requirements that each jurisdiction has that you are not going to find on the online forms. So again, good place to start because it gives you an idea of what the documents look like and what information is contained in those documents, but that is certainly not where you should stop. You certainly do need to go and see an attorney in your jurisdiction because, again, does you no good to prepare these documents, and then when it comes times to do something with it, the person can't do anything with it because they don't meet the legal requirements of your particular state.
And so two more questions, and then unfortunately we're going to have to move on because we're running out of time, but we could do this for another couple of hours because there's just so much wonderful information being shared. So thank you. But first, can you briefly speak to the intersection of charitable contributions in estate planning, or and more so just if you wanted to leave something to a charity, is that possible? Where, how, just, at a higher level.
Absolutely. Within your will, you can designate again who gets your assets. So it can be a person, it can be a charity, it can be your sorority, it can be your church, and you can designate whatever within your will you want, what property you want that person or that entity to have. So certainly, it doesn't have to be a person; it could certainly be your favorite charity that gets that.
And I would also suggest, can you hear me? Yes, I
Yes.
would also suggest, to piggyback on what Tina says, that that's something that you want to consult with your estate planning attorney with as well, because there are also charitable trusts. And depending on what it is you're trying to leave and the value of what it is you're trying to leave, a charitable trust might be a better vehicle. There are major tax implications with gifting, and a trust attorney will be able to walk you through that.
And so to piggyback off of that, because our audience is understanding and it's definitely coming home, that they need legal counsel for assistance. So when trying to decide upon an attorney to assist, what are some of the considerations or things just to take a look at or maybe consider to evaluate who would be the best fit? Any recommendations?
I think that your relationship with an attorney, especially in the area of estate planning, is sort of like any other relationship. I think that at a base level, it's a connection, somebody that you feel like is hearing you out and is got your best interest at heart for the right reasons. But then also ask an attorney that you might be considering for references for past clients that they've worked with. Ask them what their track record is. Ask them, how many trusts have you drafted? How many trusts have you drafted for estates valued at XYZ dollars? Let's say you are in a situation where you're divorced and there's an ex-spouse that may factor in. Ask them, how many estate plans have you done with given circumstances? And how many estates have you probated in Virginia? And what was the outcome? Ask, just like you would your doctor. How many surgeries have you performed like this? Ask.
And you may also want to contact your local bar association to find out whether or not any complaints have been filed about, against that attorney.
And to piggyback off of that, in the resource guide, it does take you a link so that you can find your local bar association, even for referrals for attorneys that might practice estate planning.
And then one other thing, the Google machine is always your best friend.
Yes.
And so go to the Google machine and ask the Google machine, what are questions I should ask a probate attorney? Or what are questions that I should ask an estate planning attorney? And you will find millions of resources to assist you with that.
Okay, so we're going, well, I'm sorry, go on.
I was just going to say, and for our office, what we do is we actually have a questionnaire that we give to our clients to help them start thinking. Like Cheryl said, one of the first steps is to think about what you have. So we use our questionnaire to get our clients thinking even before they meet with us, so they can kind of get a sense of what they own, who they wanted to go to, and those types of things.
And sometimes those are called property worksheets, and where you spell it out.
Yes.
And yes, the questionnaire can be found online, like Cheryl was saying, from your best friend Google, or when you consult an attorney, they sometimes will send that over to you beforehand. So we're going to move on to our last scenario. I still want you two to stick around because we're going to need to know what's the correct answer. So Erica. So Kim has twins, Ebony and Ivory. And as she gets older, Kim has experienced some health issues. Ebony, being the dutiful child, helps her mother by taking her to the doctor's appointments, overseeing her physical therapy, and even moves in with her mom temporarily so she is not alone while recovering. Ivory, however, met the Tampa Bay Buccaneers backup kicker in the club and is running across the country behind him in the name of love. So in appreciation of Ebony's care, Kim wants to leave her home solely to Ebony. She does not want to tell the twins her plan because she knows that Ivory had planned on getting the home once Kim passed away. What can Kim do? Do we have any hands raised?
Not yet, but I think they're thinking about it.
Okay.
Hands are starting.
All right, let's see.
We have Carla C and we have Ty.
Okay, let's start with Carla C.
Yeah, I would say that she needs to put it in her will that she's leaving the property just to Ebony.
Okay. And Ty, what do you think?
Hi, I think that she should do the transfer of death deed that would transfer it to her, to the daughter that she wanted to go to upon her death.
All right, ladies. Tina, Cheryl, what should she do? What can Kim do?
Well, you are correct that Kim certainly can prepare a transfer and death deed, but understanding that depending upon where Kim lives, that instrument may not be available to her because not every state has the transfer and death deed. But assuming that you have a state that has a TODD, yes, she can do that. If there is a state where that does not recognize transfer and death deeds, then Kim can do so in her will. And again, it's up to Kim. It's Kim's property to leave, and it's her decision to leave her property to whom she wants to leave it to. But I would caution that the other twin who's left out can start some mess at probate, and they can initiate a wills challenge within the probate process to say, now I know mama did not mean to leave me out of this will, and I know she meant to leave me that property along with my sister. And so there could be a wills challenge where once the twin is saying the mother had the other twin had overly undue influence on the mom. You know, if she was having some physical problems at the time, you know, physical therapy, there may be an issue whether or not mom actually had capacity at the time that she prepared the will, that whether or not she intentionally knew what she was doing when she left the other twin out. So she can do it, but know that this will probably end up before a judge to make a determination about capacity, about undue influence. And especially if you are disinheriting specifically one of your children. And in terms of that, I would just add that when a particular testator, that's the person who's writing the will, is specifically leaving out a person, when we prepare our deeds, we put a clause in there that says, you know, that these are my decisions, you know, that I'm making, not because I don't love XYZ. And we actually put that person's name in there, but this was my property and I decided these are my choices. So that will be helpful down the road if there does become a wills contest within the court, because you have clearly said in your will, I know what I'm doing, I have capacity, I know I'm leaving out Avery, and I know I'm leaving everything to Ebony, and that will help to ensure that your wishes are carried out, because the law does not want to obstruct the wishes of the testator, but the law wants to ensure that what is in the will was the wishes of the testator and they were not suffering from some other kind of outside force when they prepared the will.
Just to piggyback on what Tina said, again, this scenario highlights the importance of doing things and getting your affairs in order when you're capable of doing so. It also highlights the importance of seeking legal counsel, because an estate attorney would be able to assist mom with making sure that everything that's necessary, witnesses, notarization, every clause that's necessary to make that her wishes as strong as possible and in a manner that's going to carry out what she wants to do. And an estate planning attorney will be able to see to it that that's taken care of.
Okay, wonderful. Thank you both. And thank you, audience, for your feedback also. I'm going to switch it over now to my co-chair, Sora Kalinda Franklin.
Thank you, Sora Michelle. To our speakers, this was such a great discussion. You shared a wealth of information, and we just wanted to take this opportunity to, on behalf of the Federal City Alumnae Chapter, the officers and members, we would like to just thank both of our speakers, Sora Cheryl Steplight and Sora Tina Nelson Smith. Each of you presented information which stimulated our thinking, provided guidance and resources on what documents we all should have in place to protect our assets and build generational wealth. Sora Michelle, we didn't want to leave you out. Thank you for serving as our facilitator and subject matter expert for this program. We truly appreciate your dedication and service. We would like to present all who participated today certificates of appreciation. As you see on your screen, Sora Cheryl Steplight, Cheryl Michelle, and Sora Tina Smith Nelson. We will mail each of you your certificate and a small token of thanks to our speakers for your service today. And again, we just thank you so much for your participation. Sora Michelle.
So thank you so much. And again, this has just been an amazing activity and event this afternoon. So just a couple of takeaways that we want to reiterate for everyone. So your estate is everything that you own, as Sora Cheryl said, both real and personal property. Remember, we were told to be aware of everything that Big Mama owns, from her furniture with the plastic covering to her salt and pepper shaker collection. All of that should be included. Your basic estate plan should include 3 main documents: A will, which states what will occur after you pass away and possibly designate who is the desired guardian for any minor child. A healthcare power of attorney, which dictates who is able to make healthcare decisions for you when you're unable to communicate them, and may also specify any medical procedures that you do or do not want taken. And the durable power of attorney, which allows for your designee to make legal and financial decisions on your behalf while you're alive, but unable to communicate them. So if you own any type of land or real estate, you may want to see if the state where you reside recognizes a transfer on death deed that allows you to transfer real property, land or real estate, without having to go through the probate court. But it's important to make sure that this document is filed with your state's recorder of deeds prior to your death. Also, you want to check whether there might be any additional criteria, such as does it need to be notarized or filed by a certain time period before you pass away. So please check with a legal professional or your state office for the recorder of deeds to learn of the specific requirements. Another method of transferring assets to your loved ones is by establishing a trust. And we learned about two types: a testamentary trust, which is included in your will, and where all assets are placed into the trust upon your death, often used for minors or disabled children, and a living trust, where assets are placed into the trust during your lifetime. That method can reduce estate taxes and help with avoiding probate. And then finally, please make sure that you've designated beneficiaries for any life insurance policies or benefits, retirement accounts, and payable on death bank accounts. And whoop! That's a lot, and that's why it's time to move on this now. And AARP's Legal Counsel for the Elderly is an amazing organization committed to assisting our seniors. So to assist you with beginning or continuing your estate planning, we have compiled a resource guide that includes an overview of the topics discussed this afternoon, along with legal resources and referrals to find attorneys who do estate planning. We will send a follow-up email to your registered email address for this event. And you might even want to check because you might have an email waiting for you now. But we know that if there's one thing that COVID has reinforced, it's that we never know what may happen. So we always want to make sure that we're prepared. Next slide, please. So now, to better assist the Federal City Alumnae Chapter with understanding the impact of its programs, we are requesting that you take a 1-minute survey for this event. You either received an email with the survey link, I believe it's going to be put into the chat, or you can use the QR code on the screen. So we're going to give you a little bit of time because we want to hear from you.
Edit. 4, 3, 2, 1.
thank you again for joining us on this Sunday, Super Bowl Sunday. I would also like to thank our presenters, Ms. Cheryl Steplight and Ms. Tina Nelson, the subcommittee co-chairs, Sora Shannon Hart and Kalinda Franklin, for all of their hard work in planning this great event, the Economic Development Committee and Chair, Evelyn Coyote, the Federal City Alumnae Chapter under the leadership of our Vice President of Programs, Elaine Johnson, and President Tony McIntosh Harper, and our technology team led by Erica White and Brenda Henderson. We hope you have gained information this afternoon that will aid in your estate planning and assist in protecting and increasing your generational wealth. We can't wait to see all of our future billionaires in the room. Have a wonderful weekend and take care. Thank you.
Life is a mystery. Everyone must stand alone. I hear you call my name, and it feels like home. When you call my name, it's like a little prayer. I'm down on my knees. I wanna take you there in the midnight hour. I can feel your power, just like a prayer. You know I'll take you there. I hear your voice. It's like an angel sighing. I have no choice. I hear your voice. Feels like flying. I close my eyes. Oh God, I think I'm falling out of the sky. I close my eyes. Heaven help me when you call my name. It's like a little prayer. I'm down on my knees. I wanna take you there in the midnight hour. I can feel your power, just like a prayer. You know I'll take you there like a child. You whisper softly to me. You're in control, just like a child. Now I'm dancing. It's like a dream. No end and no beginning. You're here with me. It's like a dream. Let the choir sing when you call my name. It's like a little prayer. I'm down on my knees. I wanna take you there in the midnight hour. I can feel your power, just like a prayer. You know I'll take you there when you call my name. It's like a little prayer. I'm down on my knees. I wanna take you there in the midnight hour. I can feel your power, just like a prayer. You know I'll take you there. Life is a
Thank you so much. It was a great event. It
Thank
was well
you,
attended.
technology.
Have a good evening. Thank you, Soros, Brenda, and Janet.
Yes, thank you both so much. I'm so sorry, Janet. I didn't know you were on. I apologize.
It is all good. I don't know if we kicked out a few people that we shouldn't have. Uh-oh, hold it. I think we got a little click happy. Wait, Sora, Kalinda, and Shannon, I don't know where they are, but I didn't mean to kick everybody out. My fingers just kept moving. All right, I got a hard stop at 4,
That's right,
so
4
have a
o'clock.
wonderful
That's
one.
okay. I appreciate you. That's what I was keeping track of.
Talk to you later.
All
Bye.
right, thank you.